On August 20th, 2018, 5 days following the motions hearing, Judge Thompson simultaneously filed 2 orders, one consisting of 2 pages and the other of 3. The 2-page order accurately presents the reasons for the court's order averse to Plaintiff Pro Se Mangum in granting defendant's motion to dismiss based upon earlier courtroom proceeding. Those reasons being 1. Insufficient service of process to Defendant Durham District Attorney's Office. 2. Its resultant lack of personal jurisdiction over Defendant Durham DA's Office. 3. That the action is barred by statute of limitations. And 4. Plaintiff Mangum failed to show fraud or mistake to toll or extend the statute of limitations. The insufficient service of process is reliant on grounds that Mangum mailed and served the summons and complaint upon Durham District Attorney's Office, a defendant in the case, instead of mailing or serving the complaint on the North Carolina Attorney General's Office in Raleigh. Thompson's second basis in her order is that because Mangum mailed the complaint to Defendant Durham District Attorney's Office instead of the North Carolina Attorney General's Office, that the court lacked jurisdiction over that defendant. The third and fourth basis for Thompson's ruling in this order had to do with the 3-year statute of limitations, which expired on November 22, 2016, but which Mangum argued should have been extended due to fraud and mistake of her legal counsels by whom she had been represented during this 3-year period. During that period, Mangum was first represented by appellate defense attorney Ann B. Peterson, whom Mangum dismissed following the filing of a dreadful direct appeal by the lawyer, which consisted of a single weak issue destined to fail. Mangum discharging the attorney many months before the appellate court's ruling on the direct appeal. The North Carolina Prisoner Legal Services, a state agency, which represented Mangum through the latter part of the 3-year statute of limitations, could find no grounds upon which to attack her conviction and abandoned her 2 months after the November 22, 2016 date of expiration of the statute of limitations. The 2-page Thompson order was representative of courtroom and pre-hearing evidence in the case, but that was definitely not true of the 3-page order, which focused on the pre-filing injunction or gatekeeper ruling against Mangum. The second paragraph of the first page of that order reads, quote, "It appearing to the court from the complaint, motions, and responses filed by Plaintiff Crystal Mangum in this action that plaintiff has failed to state a claim upon which relief can be granted as to Defendant Durham Police Officer Bond and Defendant Durham District Attorney's Office," unquote. This statement, in essence, says that Crystal Mangum's complaint lacked merit, that the elements for a claim of malicious prosecution had not been met. This is false on its face. Mangum, in both her briefings and statements at the hearing, enumerated the 4 elements required for the complaint. Additionally, defendants did not challenge the merits or legitimacy of Mangum's complaint, instead relying on the issues of improper service, lack of personal jurisdiction, timeliness of filing, and qualified immunity. Neither defense attorney Rayburg nor Shields argued that the elements supporting the malicious prosecution complaint had not been satisfied. Neither of them raised the Rule 12b-6 defense, that there was a failure by Plaintiff Mangum to present a claim upon which relief could be granted. Trial transcript of the August 15, 2018 hearing also reflects that Judge Thompson, in her ruling, never mentioned the 12b-6 rule or its content, or stated or inferred that Mangum's claim lacked merit. The Rule 12b-6 was not mentioned throughout the hearing. Mangum, on the other hand, twice stated before the court from memory, as she had been denied her work product by agents of the state, that her case was based upon its merits, with all elements for malicious prosecution being met. Furthermore, she stated that the defendant's arguments were based upon technical trivialities.
There is no dispute as to the germane facts of this malicious prosecution complaint. They're arguing on the defendants are arguing on technicalities, and I'm arguing on the merits of the case, which are that the four elements for malicious prosecution are met, which are lack of probable cause, the defendant initiated the charge, there was malice involved, proven by the lack of probable cause, and the outcome was favorable to myself, the plaintiff.
What is problematic about the three-page order is that anyone reading it would conclude that first and foremost, due to its hierarchical order, that the ruling was based upon merits of the case, an interpretation that is diametrically opposite of the facts. This order by Judge Thompson is willfully deceitful in its effort to mislead the reader. In paragraph 3, Judge Thompson accurately notes Dr. Haar's intimate involvement in Crystal Mangum's malicious prosecution case, that he drafted, typed, and filed documents in it. Fact is that Mangum is incarcerated, having no access to a law library, law books, and/or the internet. Because of her circumstances, she lacks use of a laptop or keyboard and printer upon which to produce documents on her own. Consideration should be given to the fact that sometime in 2014, Dr. Haar offered to gift the women's prison where Mangum was confined a laptop computer and printer for inmate use. This offer, in 2 pieces of correspondence, received no reply from the warden. Thompson's paragraph 4, in its brevity, misrepresents and intermingles Mangum's criminal case and civil malicious prosecution case with Dr. Haar's legal discrimination case against Duke University related to a 2010 incident, and his 2017 libel and defamation case against WRAL5 News related to its online article about the 2010 incident and its aftermath. Black Rober averments resulting from Haar's legal cases were subsequently linked to Mangum's, thereby wrongly attributing baseless determinations of frivolity and vexation in his cases to hers. And in paragraph 5, Judge reasonably surmises that Dr. Haar, being neither a party in the action nor a state licensed attorney, being enjoined by a Wake County court from engaging in or aiding and abetting others in acts or practices constituting the practice of law, was in violation of North Carolina General Statutes 84-2.1 and 84-4 regarding the practice of law. Contrary to Judge Thompson's paragraph 6 assertions that Mangum and Haar abused judicial procedure in the service to the interest of justice, the exact opposite can be extrapolated from the facts as follows. 1. Effective post-conviction legal counsel by state bar licensed appellate attorneys should have timely filed or given notice to Mangum the malicious prosecution complaint. 2. Mangum had reason to believe that her legal counsel placed the interests of her legal opposition ahead of hers. 3. Had Mangum received legitimate legal counsel, the malicious prosecution claim would have been timely filed and properly served. 4. Mangum had been abandoned by the North Carolina Prisoner Legal Services as a client, and 5. Extensive efforts had been made by both Mangum and Dr. Haar to obtain legal representation from legal services of civil rights organizations, innocence projects, and from the private sector, all without success. Dr. Haar's involvement in this malicious prosecution case was exclusively as a last resort, and only after abandonment by the Prisoner Legal Services January 17, 2017 correspondence to Crystal Mangum. Justification for the hearing's pre-filing injunction, based largely on Haar's legal activity as mentioned in Thompson's 3-page order, is countermanded by her refusal to allow Dr. Haar's input by either voice or publication. Haar's attempt to address the court and Mangum's attempt to have him testify under oath being quashed by the judge. As in Crystal Mangum's prior legal actions, and due to severe constraints placed on her due to state prison confinement, Haar was heavily involved in the preparation and execution of the extremely complex appellate process. It should be kept in mind that Haar and Mangum had weekly visitations and numerous phone calls throughout the nearly 6-year post-conviction phase, during which they discussed in depth all aspects of her case. On February 1, 2019, approximately 5.5 months following the August 15, 2018 hearing in Durham Superior Court Civil Division, Mangum, through Dr. Haar, manually filed her appeal with the North Carolina Court of Appeals in Raleigh. It contained 10 issues of reversible error by the Durham Court. The first, and without doubt, the overridingly most important issue of reversible error was deprivation of Mangum's presentation documents or work product at trial. Specifically, Mangum was denied her right to due process as guaranteed in the 5th and 14th Amendments of the U.S. Constitution when she was forced to represent her case by memory without assistance of her work product. Prior to transport to Durham for the hearing, Mangum, representing herself pro se, was ordered to leave her work product at her cell in the prison located in Goldsboro. It is unprecedented for a courtroom party, represented either by counsel or pro se, to be denied assistance of work product and forced to present his or her case and counterarguments by memory alone, as was the instance in this case. It is unheard of and represents a case of first impression. Hardly a fair setup, especially with opposing state and city attorneys having access to laptops and an assortment of papers and documents on their table from their briefcases. Furthermore, Mangum, with her hands closely cuffed, was provided with no pad or writing implement by which to take notes, a disadvantage not shared by defendants. These procedural inequities put forth in the first issue of appeal represented grounds in and of themselves for the lower court ruling by Judge Thompson to be reversed and remanded to the Durham Superior Court. Issue 2 of the appeal was about the statute of limitations and the exception to date of accrual of its enactment due to issues of fraud or mistake per Rule 1-52(9). Mangum's argument that fraud and or mistake by her legal counsel prevented her timely filing of the complaint being disregarded by Judge Thompson. Issue 3 of Mangum's appeal challenged the judge's agreement with the service of the summons and complaint being improper, the United States Postal Service failing to send Mangum the return receipt with no explanation by the Durham Postmaster or the United States Postmaster General. Issue 4 dealt with the problematic pre-filing injunction against Mangum, which was baseless and linked to legal actions by HAR in which it had absolutely no nexus, its grounds for reversible error being previously discussed. Issue 5 had to do with the court's decision to deny Mangum the opportunity to present Dr. Har as a witness, while at the same time allowing into evidence statements by defense attorneys about Har and his interactions with the judicial system. At its core, this being an ex parte submission by defendants. Issue 6 averred that the court committed reversible error in not granting the default summary against defendant Durham District Attorney's Office when it failed to timely respond to the summons and complaint served on the Durham District Attorney's Office by the Durham Sheriff's Department. Issue 7 stated that the lower court, Judge Thompson, failed to grant Mangum's motion for summary judgment when all elements of the claim were proven by the plaintiff and unchallenged by defendants. Issue 8 stated that Judge Thompson committed reversible error by not considering Dr. Har's exhibits prior to making her ruling, some of the exhibits relating directly to the malicious prosecution complaint. Issue 9 had to do with Judge Thompson not issuing a ruling on Mangum's motion in court to have the 18-page document from medical examiner Clay Nichols' personnel folder unsealed with a copy given to her. Issue 10, the last issue on appeal, had to do with evidence in support that Judge Thompson had material conflicts of bias and desired outcome and was not an impartial adjudicator, related in large measure to her judicial appointment by Governor Roy Cooper, Cooper's involvement in the Duke Lacrosse case, and Cooper's unsubstantiated and false statements about Crystal Mangum upon which the media based its vilification of her. On May 8, 2019, the three-judge appellate panel heard Mangum's appeal in conference. And 3 months later, on August 6, 2019, the North Carolina Court of Appeals filed its unpublished opinion, written by Judge Phil Berger, Jr., with Judges Chris Dillon and Valerie Zachary in concurrence.